My name is Michael, and I am a writing, reading, speech coach at the Learning Commons of College of DuPage. This is part 3 of the legal writing web series where I will be discussing motions. Some people also call these trial briefs and some other people call them legal briefs, but essentially it is the most important filing that you will be doing as an attorney or paralegal. I am an inactive California attorney, which means that I did pass the California bar. I did practice for several years in California, but I am currently inactive and not practicing at the moment. When I practiced, I was in civil litigation and workers' compensation litigation. What that means is I wrote a lot and then I argued in court a lot. So these motions are pretty much the main thing that I did. So this is the second of the 3 main types of legal writing. As you can see, I've called it what is a court filing, and I've also called it the most formal writing that you'll be doing in the legal field. This will take most of your time during the working day. You will be doing a lot of research, you will be doing a lot of writing, you will be doing a lot of rewriting. If you are fortunate enough to have a firm where someone is going to take you under their wing and mentor you, you will be doing probably anywhere up to over 15, 16 drafts before it's almost done. And that's going to really be at the outset as you are starting to learn how to write professionally. I've kind of combined on this slide legal briefs and correspondence. And the main reason for this is that there's really a very, very basic 3-part outline that applies to both. And that's going to be your introduction, your body or your argument, and your conclusion. Now, even though pleadings and letters do not look anything alike, they have that similar structure. In the introduction, you basically are saying, I'm telling you what I'm going to tell you. In your body or your argument, you're going to actually tell the reader what your point is. And finally, in your conclusion, you're going to restate or tell what you already told the other reader. You're obviously going to need other parts to complete this structure of the document, like a rule of law section for a brief. You might have some additional facts. You might have some statements of law in a letter, but this is going to be the general format. So this is the overview for the trial briefs. Essentially, you're going to include 5 main sections. You're going to have an introduction, you're going to have facts, there's the argument, the conclusion, and finally the prayer for relief. Your motion should have these basic sections. I'm going to talk a little bit more about each one in turn. You can also subdivide these and combine these in a couple of different ways. This 5-section pattern is not set in stone. In fact, your argument might be the most complicated section, but we'll get to that in just a moment. Trial briefs introductions should do 2 things primarily. 1, they should clearly state your request, and 2, they should clearly state the reasons why the court should grant or deny your motion. There's a few samples there. An example for the first one, clearly stating the request. The defendant moves the court to grant this motion for summary judgment. And then you'll notice there's a name tag there for motion. If you didn't watch the first seminar, you might not understand what the name tag is doing. But basically, this is saying, for the rest of this motion, I'm going to use the word motion to refer to this motion for summary judgment. Then under the state the reasons for grant or deny, I've got 3 samples. Plaintiff cannot prove defendant owed any duty. Plaintiff cannot prove defendant breached a duty. Plaintiff cannot prove the breach caused any damages. So those are very clear reasons, and if you know your tort, you know those those would be the main elements that a defendant would bring up in a motion for summary judgment. Now remember that the judge has about 30 cases to hear on any given day in any given court call, and they might have multiple court calls in one day. If he or she thinks that your argument is worthless, you're just going to upset the judge. Make it clear from the get-go that you have statute or case law support and that your facts fit those rules. Now, even though you need to include a rules section, the judge already knows the rules, okay? They know what duty, breach, causation, damages is. It's just that game that we have to play to always write it out in the motion. Everything must be supported in that motion. So remember that when you're going through, for example, these reasons to grant or deny, coming back to this negligence concept, the plaintiff must prove each one of those elements. If the plaintiff fails anywhere, the defendant wins. And that's why it's so easy as a defendant to write a motion for summary judgment and usually be successful. Now, it's a very high standard, depending on your jurisdiction, to win at a motion for summary judgment. And it's a very low standard to actually overcome. But if it's easy enough for the defendant to give it a shot, basically. That standard is there must be some triable issue of fact. Okay, that's what the standard is. If there's a triable issue of fact, if there's something that is not clear or something that is disputed after discovery, then the defendant should lose that easy to write motion for summary judgment. The request and the specific reasons are generally going to be combined in some fashion. One firm that I worked for wanted the reasons listed as bullet points. Another firm preferred it all as one sentence, almost like a thesis sentence for a college essay. Either way, a lot of it depends on what works best for that particular motion, that particular response. But of course, if your supervising attorney tells you to do it one certain way, then you should probably do what the supervising attorney tells you to do. The next thing we're going to discuss are the facts for the motion. Just like case briefs, you're going to need to include legally significant facts. Unlike a case brief, these are going to be things that you come across in discovery, things that you find when you're reading the medical record, things that you find when you're reading through a deposition. So, as far as the length goes, there's really no set answer. Each case is going to kind of have its own sort of length. For example, a contract case might have a lot of legally significant facts that heavily rely on dates, facts, and figures. A trust contest may contain years of significant family history because all of that is relevant, or at least that's the argument, that all of that is relevant. A personal injury motion facts section tends to be short because a personal injury, a motor vehicle accident, is generally based on a brief moment in time. Literally a split second causes that motor vehicle accident. Now, there's other things to it. There's, you're going to discuss the weather. You're going to discuss whether the defendant was running late and was blowing prior stop signs or prior red lights. You're going to include all that, but the facts section is going to be still relatively short. Okay, the next thing that your trial brief facts section should have are legally significant facts. So, for example, what is a legally significant fact? The color, the make, the model of a car is probably not legally significant in most motor vehicle accident cases. The weather is probably not significant in a trust contest. But weather would be highly relevant for a motor vehicle accident. So each of those particular things come into play. You have to think about what your case is about, what you're trying to say, and what you're trying to get the judge to rule, okay? Finally, your trial brief facts should slightly spin the facts in favor of your client. As a young attorney or paralegal, you need to learn how to slant those facts to favor your client but still remain objective. It's very tricky to pull off, but once you master how to do that, you are going to become well-liked within your office. All right, let's take a look at a real case. There was a real car accident that involved two Lego cars, right? So the red car was turning left, while the yellow car was driving straight. There are no other witnesses, but this is a controlled intersection. So for those of you that aren't familiar with the phrase controlled intersection, that just means there was a stoplight or a stop sign or something that controls the traffic. We'll go ahead and presume that it was a stoplight. So think about how to spin the facts to support the plaintiff's case. So what would be interesting to me is to actually talk to you right now and figure out who you thought the plaintiff was. Was the red car the plaintiff? Was the yellow car the plaintiff? And why did you choose that to be the plaintiff? So if we're saying the red car is the plaintiff, you might have argued that the red car had a green turn arrow. That's why they went and turned into the intersection. If you were thinking that the yellow car was the plaintiff, you might argue that the yellow car had a green light, and that's why it went into the intersection. Keep that in mind, that there's always going to be two different sides to this case, and almost certainly each party, each driver is going to say that they had the green light. Very rarely would you go to trial on a case where liability was admitted. That is possible. As I say it, of course, there's an exception, because maybe we're going to issue, the trial is on the issue of damages and how hurt somebody actually was. Anyway, also think about how to spin the facts as the defendant for whoever you picked as the plaintiff. Think about what the other attorney is going to say about those facts. That's going to help you plan your discovery, okay? But we're not talking about discovery now. We're talking about the motion that you're writing. So the answers to these questions that we asked ourselves about how we're spinning those facts, we're going to get that in discovery, but like I just said, we're not talking about that right now. So let's pretend like we have all these facts, right? But these are other questions you want to keep in mind. What's the human element behind all this? Was one of these two drivers late for work? Was someone driving home from work after a long day? Maybe someone works the night shift and they're driving home, and the other person works a shift 1 and they're driving to work. Was one of these drivers out drinking? And the time of day might say a lot about the character of that person who was drinking. So these are all things you want to keep in mind as you are preparing your facts for your motion. Okay, the next thing I'm going to discuss is the argument. All right, so here's the argument, and this is going to be the main section of your trial brief, of your motion, whether you're responding to one or whether you're writing one. The argument is the heart and soul of this brief. You usually cannot win a motion on paper, meaning you can't win it just by writing a response or writing the motion. You will often have to have oral argument, but you can absolutely lose your motion if you do a horrible job in your argument section. Fortunately, though, many of you will be under the guise of some supervising attorney who probably won't allow you to file a terrible response. So the next thing I want to talk about is how the argument is going to use IRAC. And if you've had any sort of legal writing classes, you are familiar with IRAC. But if you haven't had that concept yet, I'm going to briefly talk about what IRAC stands for, and that's issue, rule, application, and conclusion. This is the basic legal outline to any formal writing. In fact, any writing at all anything outside of a case brief is going to probably use IRAC in one way, shape, or form. I'm not going to be able to adequately discuss the finer points of IRAC here, but essentially you are going to identify each issue via the facts. For each issue, you are going to state the law, which might be found in either statute or case law. Then you apply the rule that you've synthesized to the facts that you have in your case. Finally, to hammer home the point you just made, you're going to conclude it and tie it all together and say why you should be successful. Coming back to the motor vehicle accident we just discussed, the Lego picture, you're going to know the issue, you're going to have memorized the rule, and your analysis and your conclusion will follow from that, always. Once you have those rules memorized, research becomes a whole lot easier. Knowing the issue is as simple as talking to your client, understanding what the discovery responses are, figuring out what you need to prove in court to be successful. There will likely be many IRACs in your trial brief. Each section should be significant enough to lead to your main point. Otherwise, what's the point of having a mini IRAC if you're not going to prove a point for the judge? Finally, the last thing I want to say about an argument is that it forces you, the writer, to think. The best thing you can do in any case is to know the facts. This is true in writing motions, arguing motions, anything really in legal. The more time you spend on your argument, the better off you're going to be, whether that's the researching side of it, the writing side of it, the rewriting and the rewriting and the rewriting side of it. All of those things are going to make your argument stronger. One thing I want you to remember is that there is an equally talented paralegal or attorney team at the opposing counsel's office that is going to be writing the exact opposite motion. They're writing the response. They're writing the reply. They wrote the motion, right? They're spinning the facts differently. They have the same set of facts. Those are undisputed, but they're going to be putting their own spin on it, why their client should be successful in this motion. So they're most likely equally talented, and the longer you practice, the more likely it is that you're going to know who that other firm is, and you have met them in court or you have met them at a function. You know who they are, and you know how they're going to operate. You're going to conclude your trial brief by doing a few things. First, you're going to restate the main reasons for the motion. Those are the same exact things that we stated at the very beginning in the introduction. Then you're going to use the phrase, most likely you'll be using the phrase, wherefore the plaintiff or defendant requests the following. Now, I say most likely because some firms are moving away from using legalese like the word wherefore. Anyway, however your firm appreciates their writing to be done, do it that way. List your requests. If you are trying to defeat a motion, you are saying that the judge should deny the motion. If you're trying to have it granted, then you are trying to have that motion granted. You might have 4 or 5 different other things, right, that are listed in your request. So you want to be concise, but you want to follow all local rules. It is almost certain that you cannot have any relief that you didn't pray for, even if your argument is a slam dunk. If you forget to write that defendant requests that the court dismiss the case, the court may not actually dismiss your case. It's unlikely, but it's possible. If you didn't request it, even if that's what the point of your motion was, if it wasn't in the request, you may not get that case dismissed. And then you will have truly wasted a lot of people's time, money, and effort. The reason for this is because there's notice of process issues. If you haven't put in the motion, we want this case dismissed, then technically the plaintiff's going to argue that we didn't know that they wanted the case dismissed. This is going to be especially true in jurisdictions where the judge's clerk is just going to type up the prayer as the order. You should always include any other relief that this court deems proper. That's going to be that sort of catch-all phrase that ideally, if you forget anything, but the judge knows that the judge wants to include it, then that phrase allows the judge to include it as long as it's proper. But again, if you're writing a motion to dismiss, you should absolutely request that the court dismiss the case. If you have any questions on the information presented in this webinar, please feel free to make an appointment in Learning Commons. This is some general information about our location and hours. Look forward to hearing from you, and please stick around for part 4.